Settling in a state is an unsettling time for any family, and as emotions run high, problems often follow. Dragging your relatives to court may not be the best solution to an estate dispute. Seeking a more moderate resolution process can speed up the settlement and heal the wounds faster. In Atlanta with a look at estate mediation is Adam Gaslowitz. He's a managing partner of law firm Adam R. Gaslowitz & Associates. Adam, good to have you on the show. Thanks for being with us.
It's good to be here.
We've talked before on this show about arbitration and mediation, but alternative dispute resolution is really a good option in many cases for people in an estate dispute. Are there characteristics of a particular dispute that would lend themselves better to mediation than to a court case?
Well, most estate litigation is probably better resolved in mediation if possible. Estate disputes are involving families that often are very litigious and protracted. So if you can get them into mediation early on, you often have the ability not only to resolve the dispute, but to preserve the family relationship if it can be preserved.
Under what circumstances, and I guess this is very, very, very hard to generalize, but under what circumstances should you contest a will and set the wheels into motion of what could be a very long drawn-out and damaging process?
People generally contest wills when an unusual will appears or when an incompetent parent has signed documents that leave assets in a way that is unusual to the family, perhaps leaving assets to one child and disinheriting other children, or leaving assets to a surviving second spouse and disinheriting all the children from a previous marriage. A lot of times if one child has control over an aging parent, maybe they're taking care of that parent in their last years, and then all of a sudden assets start being transferred or bank accounts start appearing in joint names. That's usually a time when people start to contest wills.
What's the process? If you want to contest a will, or you are you're one of the parties to that will, you've got to get agreement. When you're talking about mediation, often that's something that both parties or multiple parties have to agree on. In fact, not often, they always have to. How do you get that process going?
Well, you're right. Generally, the parties do need to agree to it. In certain court systems, the courts will order you to mediation, and in that case, the parties are forced to mediate. Unfortunately, that doesn't always resolve the problem. If people don't want to mediate, then the result is often not very good. A lot of times what it takes is the attorneys involved in the case to push the parties into trying to resolve a case in a shortened fashion as opposed to in a protracted litigation. But usually in these types of disputes, you've got parties who have a lot of heated emotion, and often putting them in a room together where they will sit down and try and resolve their problems in an amicable fashion is difficult. So you usually rely on the attorneys to convince them that the cost and the results are too uncertain, and that they're better off trying to resolve the problem now before the problem gets out of hand.
The outcome of mediation, whatever that settlement ends up, is it even called a settlement? What is it called, and how final is it?
If you resolve it at mediation, then there's usually a settlement agreement signed. The smartest thing to do is to make sure you sign an agreement at the settlement. A lot of times if you don't sign it there and you leave, people's memories fade and suddenly you don't have the settlement you thought you did. So usually you'll stay until you've either resolved it or you've reached some sort of an impasse. But it's important to get it in writing so that what you agreed to, what you thought you agreed to, is what everybody signed off on.
Can you and should you, and I'm really walking in the lion's den on this one, should you do this without an attorney?
You can. I don't recommend it. There's certainly mediation set up in many places around the country where neighborhood justice centers will mediate for you without attorneys. It is helpful to have attorneys with you because a lot of the issues that you are discussing in mediation, even though they're not necessarily binding on you later, can create problems if the case doesn't resolve. So that if you leave mediation without a resolution and you end up having to proceed down the path of litigation, you may have hurt your case by some of the things you said in that mediation. So
what do you do if you're on the other side of things, so to speak, if you're the person whose will it is? Are there things you can do to protect your estate from being the subject of a dispute?
Well, the only thing you can do to keep your will from being disputed is to not die, and that's not possible for most of us. So the next best thing is to try and do things that will either limit the likelihood of a success in a will contest, or to at least discourage people from doing it. One of the best things is communication among parents and kids. A lot of times the estate planning process is done in a vacuum with the parents without ever discussing with children what's going on. So that's one thing you need to do. But taking basic things into consideration, like if you're in a second marriage situation, taking into consideration the fact that you've got children from a previous marriage, and if you don't plan your estate right, you may effectively disinherit all your children, will lead to an estate dispute. Taking into account the fact that you may not want to treat all your children equally is something to consider, because that will lead to an estate dispute. Putting no contest provisions in a will can sometimes convince people not to file a will contest, but that doesn't always work. You've got to have something at stake to lose before no contest provision will have any teeth to it. So those are things people ought to consider. A lot of times people get into estate disputes because they just didn't plan well enough.
Yeah.
They didn't consider some of the things that might happen at the end.
Well, that's what we're going to try and address tonight. Adam, thank you for being with us.
My pleasure.